250, and a myriad of statutory provisions that I could bring here, all talk about ethnicity as a constitutional principle worth defending, worth being held to account for, worth advocating. All of those mention the word. In fact, I found that the word ethnicity appears more times than the word economy. Economy appears twice. Ethnicity 11 times. So, you know, how can you be accused of speaking of an issue the Constitution spent 11 articles talking about? But even more important, in 2016, the late Justice Louis Onguto had occasion to consider a case I have circulated to my colleagues this morning after I got their submissions, and I think I have given the court, my good friend Mr. Njomo, had the court's copies. But this is the case of Ferdinand Dongo Waitito, also known as Babayao, and 4 others, versus the Attorney General. It's reported. This is what Judge... such as those about to be made by the respondents. And this is what it says. The Constitution allows every person to picket, demonstrate, assemble, and present petitions. Picketing and demonstrations themselves invite the right to express opinion. The opinions may be controversial. The opinions may appear contrary to the law. Appear contrary to the law. This is Judge Onguto saying this. The opinions may not find favor with others. Yet, the Constitution anticipates and expects that such unpopular opinions, howsoever expressed, be respected. Now, not all of us can speak as good English as my good friend Dudley or my good friend Professor Ojiambo here. But you're free to express yourself as you will. If you read a document that talked about shareholders, that is what you say when you go to the public. Why would you be vilified and impeached from ever holding public office for reading a document that founded a government? On what basis? He then says, even if they invite disagreements and counter demonstrations, this is the first time, I think it's good, Kenyans would know, counter demonstrations are allowed. Not just demonstrations, even counter. The Constitution thus far declines to stifle even the most unpopular view unless it is intended to incite persons to violence, propagate hate speech, is propaganda for war, or advocates hatred through ethnic incitement. When you retire to look at the provisions of the National Cohesion Act, sections 13 and 62, that are the basis of these frivolous grounds, they say the critical function is what my professor, Gideon Muigai of criminal law, used to tell us was called the mens rea, the intention. Did you have the intention to cause hatred and incitement? You cannot have had the intention when the document you are reading is the basis for the government that was formed. You cannot incite people with the government. You reward them with a thing nowadays called power and economic empowerment. You do not incite them. You can't cause hatred by talking about a government that was elected by people on the basis of a document. And so the DP's public references as regards these shareholders cannot be tantamount to hate speech. They cannot. This is public speaking, as I've just stated. And I should state here, the case of Ferdinand Dongo Waitito and the 4 others, among the 4 others are the current leader of majority in the National Assembly. So he knows this. When they were considering these grounds, he was aware of this decision because he was one of the petitioners. And they were told, no, you can't stop people from talking. Now, but then, they then went to the Supreme Court, the Court of Appeal, sorry. They tried to overturn this decision, and the Court of Appeal rejected that attempt. So this decision, I'm reading Ferdinand Waitito, has been upheld as well by the Court of Appeal. There are many instances where one would be said to have caused the hate speech or incited people or have said things that weren't popular. The first petitioner is accused of having spoken against the National Intelligence Service. When you retire to review the material before you, this is the Senate Hansard, and this is ground number 9, which you'll find at page 64. There is an interesting exchange where my good friend Ekomas Mutuse is being interviewed, is being cross-examined. on the question of the NIS. And he's directed to a case where the current president, who, while deputy president, also very harshly criticized the NIS. So criticizing the NIS has not started now. In fact, the current first petitioner, who was the deputy president, should be accused of being a good student of his boss, the former deputy president, who's currently the president, because he too also criticized the NIS. So, and the NIS, as with any other state organ, can and should be criticized. No one is beyond criticism so long as it is well-founded, as turned out in this case. It is made politely. It is stated in good English, relatively good English. Our client spoke some fairly good English. He's a literature graduate. He said nice things. He said them nicely. Now they offended the heart, but you know, no one is beyond criticism. One of the other things, I think, and we've stated this in our petition in submission, again on the question of bias, the National Assembly Deputy Speaker, the 8th respondent, is on record as saying her instructions to execute the impeachment came from a building in Kilimani called State House. And one of the things the court is invited to look at is whether the person exercising this decision acted on the direction of a person or a body not authorized or empowered to give such directions. Now, one of the other issues that this court is asked to look into is whether the administrative action is rationally connected to the information before the administration. Again, as I have said, it cannot have been rationally connected to this decision when among the grounds was a law that did not exist, was issues pending before the succession court, was the exercise of freedom of expression under Article 33. I will not repeat the question about the issue, but it's one of the other issues, again, you'll be able to look at. The question of these shareholder agreements, I need not say any more about that. But is the decision unreasonable?
The ungodly rush to execute a premeditated decision is unreasonable. A one-day notice to the public to conduct public participation regarding a matter that even this court has said is of great public importance is unreasonable. Conducting public participation in which the public only has access to the impeachment motion, a summary of it, by the way. The evidence was not given to the public. They were just told he has violated Article this, Section this, and Section that. Most lawyers could not tell you, with most, leave alone the public, other than my good friend Mr. Umtata. No public member can read these sections out of their head. And yet this is what they were given on this document and told, should we impeach this man or not? Passing a resolution based on public participation, as I said, that had 0% of voters who cast the votes in 2022, is unreasonable. One of the other criteria is whether the administrative action or decision is not proportionate to the interests or rights affected, and whether the impugned action or decision violated the legitimate expectations of not only the deputy president, but the nation at large. Now, the case I cited earlier, which is the 2025 IBC versus AG case, states the following words. Kenya's history is one of executive overreach and institutional compromise. This is what the Supreme Court said last year. And for the avoidance of doubt, Section 12 of the Fair Administrative Action Act states that the act is in addition to and not in derogation of the general principles of common law and of natural justice. Now, as I said, the National Assembly and the Senate violated all known canons of fair hearing and constitutional procedure. Amongst the most harmful things they did was to destroy almost the principle known as the